All right. Good afternoon, everyone. This is Curt and welcome to Fire Law Roundup. This is the Roundup for February 7th of 2022. And I've got my good friend here, Bill Maccarone. He is pinch hitting for Brad Pinsky. Brad is somewhere in Texas. He wasn't very forthcoming with all the details, but he said, unfortunately, he had very slow internet. And he said it came out, he did a couple of tests and it came out very choppy. So Brad won't be able to join us, but we got Bill Maccarone here pinch hitting, and that's fortunate because there was a big case, there's another of the many FLSA cases that came down last week. Bill covered it in his blog, and so this is going to give us a chance to talk about that case. But Bill,
Absolutely.
first of all, welcome, and let's tell us about the case.
Well, before I start, I think it's about 25 degrees outside, and I know last time Brad was was it some Tahiti or some island?
Yeah.
Now he's in Texas, so I don't know.
Yeah.
But anyway, the case is from Tulsa, Oklahoma, and it's an FLSA lawsuit that was filed last week. It was a group of 13, I think. I look at my notes here, 13 firefighters that looked like it was their executive board when looking at it. It looked like that was kind of the named plaintiffs, because sometimes you'll see that in an action like this where the executive board kind of will be the named plaintiffs in a lawsuit, and then eventually others will jump on through the process. That's how those collective actions work. And the facts, just kind of boil it down quickly, is a couple of relevant things here. In Tulsa, they work a 24/48 schedule, very common in the fire service. They're on a 27-day work period. So being on a 27-day work period, anyone that's taken our FLSA class kind of looks at that, and you start to kind of, game this out, and you think, okay, this might be a little challenging paying the FLSA overtime because of that work period being 27 days and not most likely lining up with a pay period. So there's some challenges there. It's not insurmountable, but there are definitely some challenges. And to add to the complexity, these folks in Tulsa, they get a Kelly Day, but they don't call it a Kelly Day. They call it something a little bit different. Same basic premise. It's an hours reduction shift, but they're not providing that shift every work period. They're providing it essentially every other work period. So we know what that creates is there's going to be some work periods where the firefighters are scheduled to work some overtime. And then the work period that they have that reduction day, that planned day off, they're going to be well under the threshold. And I say well under, probably 12 hours or so under the threshold. So you're going to have some work periods where their old FLSA overtime just coming to work their shifts, and then the next work period they won't. So some reason, at least according to the firefighters' complaint, around April of 2021, the city just stopped paying FLSA overtime on that 27-day work period that they were scheduled to, and actually worked over the max hours for the work period. Obviously, in theory, having that Kelly Day is supposed to bring you down under, or that work reduction day down under the hours. But if you're not going to give that Kelly Day or that work reduction day every work period, it's not going to have the desired effect on your work periods that you didn't get the day off. So it was a little bit of an interesting fact there that they, that the city, for some reason, just stopped doing this, almost a year ago. So the lawsuit's been filed. It'll be interesting to see where it goes, what the follow-up story is, and what the city's defense is going to be, and what they're going to raise. But obviously Tulsa is a big department, and the attorneys there's an Oklahoma attorney, but there's also a law firm out of DC is handling this. They're very well-versed in FLSA lawsuits throughout the country, representing firefighters. So there's no doubt they're going to do, a good job with it, if depending on the facts, obviously. And there was a second argument that was made, or a second claim, which is very relevant too. And it was a time of payment claim. And on the FLSA, you have to pay basically the payday following the end of your work week is when you should get your overtime. Now, obviously, when you look at this 27-day work period, when you take into account all the different things, the different rules that only apply to firefighters, under the 7K exemption, it can make that time of payment a little bit tricky. And like I mentioned, with the 27-day work period, you definitely, there's a lot of moving parts there as far as when do you get that overtime pay. And according to the complaint, it looks like the city was, playing some, again, according to the complaint, but playing some games with the way they paid out the overtime for unscheduled shifts. So say a firefighter worked an extra shift, according to the complaint, and now this is 2022. They had to fill out a paper form and submit it with headquarters to basically get paid for that extra shift that they were working. And at least there was one instance they were able to claim that it was 38 days before the firefighter got the overtime that he or she was due. That's a little too long. That's, you can get away with a week, you can get away with the paycheck after the end of your work period. That's certainly because how else are you going to do it when you think about it? But 38 days is a long time to go without pay. And I'm sure it wasn't a one-time occurrence. I'm sure it was a system. You're not going to have a lawsuit because of something fell through the cracks and, you didn't pay someone for 38 days and then you found it and paid them. That's not going to end up in federal court, in my opinion. But when there are other factors and other things and systematic, over a period of time, that's when you find yourself in that situation. So that's
one of the things that I know we talk about, and you and I, we call it the Chicago suburban schedule. Is that a 28-day work period or is that
27 day? It's 27 day.
So if you give that extra work period, and the folks who've been through the FLSA class will kind of maybe connect some of the dots here. If you give that extra day, in theory, it should eliminate the need for overtime, but you've got to change your work period.
Exactly.
Right. And you can't just have the same 27-day work period and then expect this to eliminate overtime. You've got to do it
exactly.
There's a specific way. Well, we talk about that in the class. I don't want to get too deep in the weeds here. But that was one thing, I didn't know if maybe I don't know.
Well, it's funny you say that because the frequency of the Kelly day, though, or this work reduction day, doesn't match out.
It's not every other work period. It's not every other.
It's not an attempt to straddle work periods because
I got you. That's a good straddle the work periods.
Yeah, it's every 39 days or so that they got this work reduction because it was after every 14 shifts. So I believe it was their 14th or their 15th scheduled 24 that they got this work reduction day, which in theory, you're absolutely correct. But it's more like, I'm trying to think in my head.
54, is it 27 and 27? 18. 54.
It would be 18, exactly. Every 18 work shifts or every 54 days. Yes.
Right. Yeah.
So they're according to complaint, the magic. So that's it's interesting, and I think we'll definitely it was just filed last week, so I'm sure there isn't even an answer yet because it was just filed on the 1st. So we'll have to see where it goes.
Cool. I want to, one of the challenges here, we can't spend a lot of time on all the cases, and but we do have our FLSA class coming up next week. So for those of you who are interested, maybe have been thinking about taking it, we've got it next week. Runs Tuesday to Friday, 4 days. So so all right. Couple of other cases here that I wanted to kind of cover. I'll just run through the ones that I covered, and then there's a few others that will be in the newsletter that's going out tomorrow. But the first one was a race discrimination case that was settled out of Everett, Washington. Federal claims against the Miami-Dade Fire Rescue over an EMS incident were dismissed. Now we'll talk about that one in a little bit more detail in a second. Interesting case out of Massachusetts where a deputy chief who had been terminated over a domestic incident. Apparently, he had been dating a female police officer, and there was something that happened. It's not totally clear what happened, and you want to give folks the benefit of the doubt. So something happened. He ended up arrested. He ended up getting terminated, and there was quite a bit of litigation over it. But the bottom line is he challenged the termination and felt that because there was some evidentiary questions about just what happened, there was some truthfulness issues, not on his part, but on on the part of some of the witnesses, that he should be reinstated. And the case this is a Massachusetts case, and Massachusetts has this statewide civil service commission, and the civil service commission agreed to some extent. They said, you did something wrong, but it didn't warrant termination. So there was definitely something that the department was justified in disciplining you, but it didn't warrant termination. So they ordered him reinstated and demoted to firefighter. So here was Massachusetts, the deputy chief is the number 2. That's your 4 bugle position. So he went from chief of department down to, deputy chief, number 2 in the organization, down to firefighter. So interesting case. For those of you who have been through either the discipline class or more particularly the credibility determination class, the Mass Civil Service Commission, once again, did an excellent job about explaining why they believed one employee versus another, or one witness versus another. And that's something that if you're a fire chief or you're an investigator, or even an officer, really any officer, you can't just say, I believe A and I don't believe B. You can't just, like you think about a judge in a courtroom banging the gavel and saying guilty. You can't do that. You have to be able to say, I believe A because, and then be able to explain why. It's not because they blinked their eyes twice and they started sweating. You've got to be able to say something that is credible, okay, in terms of your explaining why you believe this person versus maybe person B who you don't believe. And again, the Mass Civil Service Commission does a really good job of making those credibility determinations. So, and I know in my class I hand out some of those, some of their decisions as examples of how we want to do things. Next one was Oregon. We had a lawsuit filed, and we'll talk about that one in a little bit more detail in a bit. And then the last one is something we talked about, Brad and I had talked about last week, was just that San Diego vaccine mandate case. So, Bill, any of those you want to, I don't know if you feel, I know we kind of caught you by surprise here. So, but if any of those cases that you want to.
Well, I was interested in the case, and I was reading your blog on the Miami-Dade, the firefighters in Miami-Dade, and that was kind of an interesting, the fact that the plaintiffs in that instance, the family of the poor, deceased person that passed away, they tried to make a federal lawsuit out of, what would typically be these paramedics came in and didn't treat my loved one, per the protocol or whatever. And you actually raised a interesting point about that and how that's an effort to kind of overstep the immunity, because we do as firefighters, as EMTs, there's a certain amount of that immunity that you get as long as you're not really over the edge, right? As long as you're not outside of the bounds, if you're doing your job, there's going to be some immunity that's going to attach to it. And by making, you want to explain that? Because that was
no, it's an important one, and let me just I hate to quote here, but I think it's in this particular case, it's probably a good idea for us to get into the allegations, okay? And but again, understand that these are not facts; these are allegations, and that's all they are. But this Mr. And I'm not sure, I'll butcher his name, but Beaz, was having difficulty breathing. The allegation is that the firefighters came from a station which is notoriously slow. And I'll quote, the station is only 1 mile away on a straight 3-lane road. Traveling this road at a regular speed of 45 miles an hour will only take 1 minute and 36 seconds. The paramedics took 5 minutes, which, when you consider turnout, that's not all that unreasonable, but 5 minutes, blah, blah, blah. And the firefighters falsified their time en route. And either that or they drove at 14.5 miles per hour, which, again, the allegations are crazy here. And then again, essentially what they're alleging is that the firefighters came from a very slow station. They're very slow to get out. They took their time getting there. And then they, rather than actually evaluating the patient, they just pronounced them dead. So that was the allegation. And the court, in dealing with that, well, let's talk about the attorney who filed the suit. The attorney could allege wrongful death and negligence under state law. Okay. Now, the problem with those kinds of allegations are that very often in most states, we have immunity from those types of tort lawsuits. It has to be more than just negligence. So what some attorneys will do, some sophisticated attorneys will do, and this is often the case where you have attorneys that also sue police departments a lot. They'll sue and they'll allege that the person's civil rights were violated, so that in addition to the medics and the fire department being negligent, that there was a civil rights violation, that someone was, quote unquote, deprived of due process or deprived of their life without due process. Okay, so there's a civil rights, Fourth Amendment, 14th Amendment type of allegation. And so that was the allegation here. And what we have in the decision that I posted was that the case originally was filed in state court, got removed to federal court to deal with those federal issues. The federal court said, look, even if all of your allegations are true, it doesn't arise to the level of being a civil rights violation. Okay, that this at worst is maybe negligence, and you can go back to state court to have the negligence claims handled. But there's no federal civil rights here. This is, you know, if they screwed up, use firefighter words, if you screwed up, then you deal with it in state court, but it's not a civil rights case. This is, you know, you haven't made your case, and basically dismissed that ruling. So interesting case. I've got a lot more language in there. You can follow the link to my earlier coverage when the suit was first filed. We are seeing a lot of these types of cases, though, and I think there's an awful lot of litigation against police departments in the United States. And I think when an attorney maybe has some experience suing police departments, and somebody comes in with a fire-related case, they just say, let's throw this one in. Let's throw this claim in as well. And
no,
that's
absolutely.
that's my. Yeah, I think
and
it's
they still get their day in court too, because now this
Yeah.
is just going to go back to state court, and they can, you know, and in which case, I mean, that's at the end of the day, that's what everybody deserves, you know,
Right.
and it'll be, you know, the statute. They look at the statute for immunity, and they can look at the actions of the medics and go from there.
Yeah. And so, and again, you know, I hate to keep saying this. Some people get upset when I don't say it enough, but that the allegations in a lawsuit are just allegations. They're not fact. They're not statements of fact. And so that's all. What we know, all I can report on here is what is in the allegation, what is in the complaint, or what the court said. And we really don't know what actually happened. Okay, you know, I go back to my baseball analogy. You could have, you know, 50,000 people in a stadium. There's a close play at second base, and 25,000 see it one way, 25,000 see it another way. And without instant replay, you're not going to convince somebody that they saw it wrong. And the same thing can happen in a lot of these factual cases, that the parties just are not going to agree on what actually happened. So the case I want to spend a little bit of time on is this new one out of Oregon. Bill, I don't know if you had a chance to kind of look at the facts. And, you know, the facts sort of align more with what I think of as an early COVID case, as opposed to one that happened in December of 2020, because we were pretty far into COVID by December of 2020. So, but the allegations are that this happened in Oregon, and Klamath County Fire District Number 1 responded to a request for medical aid. And, you know, again, the allegations are that the medics didn't refuse to transport, but really suggested strongly that the person be transported by their domestic partner, as opposed to transported by, and I'm assuming the fire department ambulance. It's a little bit unclear, because, you know, what we think of as important in a complaint as firefighters, and in terms of understanding what happened, and what a civilian, and in particular a civilian attorney, might think is important, isn't clear. So I don't know if they are also a transporting agency, or if there was an ambulance, or what. It really wasn't all that clear in the complaint. But essentially that the fire department responded. The person had COVID, so the person was tested positive for COVID, and I'll read some of it. There's apparently two medics, and apparently the taller of the two medics was the one that offended the folks the most. But the taller of the two paramedics came in the doorway and stopped. He asked, "Where is Kimball?" Kimball being the person who ended up passing away, but she had COVID, and where is she? I'm sorry. I'm sorry, I got the facts wrong. Kimball is the domestic partner of the person. Teresa Vaughn is the woman who passed away. So Vivian Kimball is the domestic partner who actually drove Vaughn to the hospital. So Kimball is talking to the medic, and the medic says, "Where is she?" Kimball then says she's over there, and pointed to the couch further into the apartment where Vaughn was sitting, looking pale and colorless. She's having a hard time breathing. The paramedic didn't go to Vaughn and start taking her vital signs or ask how she was doing. Instead, the paramedic turned back to Kimball and said, "Can you take her to the hospital?" And then Kimball replied, "Isn't that your job?" The paramedic responded by then turning to Vaughn, and his question, and again, his question was the only thing either paramedic said to Vaughn before she passed away. He gestured to Kimball and said, can she take you to the hospital? Meaning, can Kimball take you to the hospital? And Vaughn was gasping, struggling to talk, and she said, "Guess so." And at that, there's a little exchange of information, comments between Kimball and the tall paramedic, with Kimball commenting she didn't have a choice. The paramedic snapped, "What do you want?" And then Kimball said, "For you to do your effing job." And at that point, the two medics walked outside, got in their truck, and drove away. And Vaughn ended up coding, at least according to the complaint, coding in Kimball's car as she was driving her to the hospital. And this is a little bit strange. She said that she was driving the car and doing chest compressions. I think, we all kind of get the eyeball roll, but you know how a jury's going to think of that,
Absolutely.
So at any rate, tough allegations. And again, we don't know all the details. So those are the allegations from the people who filed the lawsuit. Certainly not necessarily factually accurate. And the paramedics are not named, but the lawsuit does name John Doe defendants. So at a later date, the people who are bringing the suit, this number of family members involved, could turn around and allege that such and such a paramedic, the actual name, is going to take the place of the John Doe defendant. So tough fact pattern. Hopefully this was a situation where the medics had good documentation of what they did. That they had a signed refusal. I know in my case, when I lecture on this and to my clients, you want not just a signed refusal, but you want additional details that support your determination, including the risks that you explain to the person, the possible consequences, and that they knowingly and willingly declined transport.
Their capacity, their ability to make that decision. Yeah.
Absolutely. Because if you don't have all of that and you walk away from a situation and someone passes away, very, very, very difficult. Your credibility versus theirs. And I mentioned this in last week's webinar, or last week's video, but if you don't put it in your report when it happens, It's not that it didn't happen, okay? But the problem is it seems self-serving. Okay, so months later, when you testify, whether in a lawsuit or in a deposition, and you're saying, "Oh no, this is how it happened. I just didn't put it in my report." That seems self-serving, when as opposed to when you put it in there right from the start, you
Yeah.
had no reason to think that there was going to be a lawsuit. It has more credibility. So that's one of the big reasons why you want to make sure that you get that information in the report. So, Bill, I don't know if you have any thoughts. I know it's kind of
No, absolutely. And it's tough because again, they're allegations, the allegations in
right.
a complaint, because you can't, you read those allegations, you say, well, no, there's something's gotta be, who does that? No, this
Right.
is not, but obviously but something bad happened. I
Yeah.
mean, we can't, something unfortunate happened.
Well,
I know I've
yeah,
been in situations, especially lately with COVID, you get to the house and you're almost being led into the house by the person that you're there to treat. It's like, no, 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 I don't want to go deeper in your house. You're walking, you come to me. We're going to leave this. We're going to go out onto the porch. We're going to
right.
talk out here so I can see, there's no doubt there's those both sides of that situation.
Yeah, and I think one of the things, like certainly an attorney and a family in the aftermath of this don't necessarily understand everything that's going on in the fire service, but I'm concerned that when there is a major incident going on, like let's say you're dispatched on a medical run, and right as soon as your dispatch is a
Build a fire.
multi-alarm
Yeah.
fire, or a baby choking, or whatever it may be, that you're saying, I got to clear from this run so I can go on that run, and you're not making good. You got to make good decisions here, because you don't want to trivialize what one person's going through because you want to get involved in another thing that may be going on. Again, I'm speculating. I have no idea what else was going on, but I always wonder if there's other reasons why some of the decisions that we make may be driven by things that we really probably shouldn't be considering. And
Absolutely.
some type of thing that we need to have that conversation with some of our folks if
And
they're
the system is so overtaxed right now. I think that's a fair statement, between the hospitals and the turnaround time and the downward pressure that's being exerted on, the fire department. Say, well, why were you at the hospital for 2 hours? You're going to get back in service. And it's not their fault. They were holding a wall, right, for 2 hours in some areas. So, I mean, there's just so many different things coming into play now that really were not an issue 10, 15 years ago, in my opinion, or we're a 1 in a million type of an issue 10 or 15 years ago, where now it's almost common, everyday occurrence.
Yeah. I don't know, tough case, but we'll be watching that one out of Oregon, and again, a lot of these suits, there's no winners. It's not like you win the suit, the person is still deceased. It's not going to change that. So let's see. The one I mentioned this one before, but I do want to get into a little bit more detail, and this will probably be the last one that we have time to get into. But the mass civil service case, really an interesting case, and a lot of factual questions in there, and the credibility determination aspect of this. So I would encourage. I'm not going to go through all the facts of it. It's difficult case, but one of the things I do want to point out when we get into the issue of just cause, there's a number of aspects to just cause, and they're not well understood. And the reality is there's a lot of different definitions of just cause. So when a court, or in this case, a civil service commission, is reviewing whether or not an employer had just cause, there's a number of factors that they look at, and how thorough an investigation was done. Was the investigation fair? Was the person who made the decision to terminate biased or objective? So those are all things. But one of the most common reasons for a disciplinary decision to be overturned is because the penalty did not fit the crime. Okay, that the penalty by in this case, the Civil Service Commission, the penalty that the fire department sought to attach, which was termination, was deemed to be excessive based on the rule violation that actually took place. So that's probably one of the most common reasons for terminations to be overturned based on just cause, because they felt that the punishment was excessive. So interesting case. And again, I recommend anybody who's been through the discipline class or the credibility determination class, take a look at how the Mass Civil Service Commission handled that credibility determination between the firefighter and a civilian who also happened to be a police officer.
Those are usually good reads too. Those, when you read those civil service type of, it's a story, it really is. And they're not, some cases can be difficult. I mean, we all know, and it's, we enjoy them. Sometimes we enjoy reading something and the average person says, what was that? But those are really good to, in my opinion, those are really good to.
Absolutely. And there's one, Chris Bauman is one of the commissioners, and another one, Phil Stein, I believe his name is, who wrote this one. I would love to get them on here and talk, but I don't think they would. And for good reason, because they have to make, they have to make objective determinations, and it's probably like trying to interview a judge about a case. They just, there's nothing to be gained. Although I think there'd be a lot to be gained, because giving us as firefighters and firefighter attorneys perspective into the decision making would be valuable. But I just think from that end, they probably would not be willing to have the conversation. So.
No, agreed.
All right. So couple of last minute things. One, please subscribe if you haven't. We need to get us up to 400 subscribers. It has been coming up in the last few weeks, but please subscribe. Also, I got to find my book. Where's my book? Here we go. The 4th edition is out, and we're going to give away a free one to a randomly selected person once we hit 500 subscribe. So please, please join us on here, and we'd love to have you as a regular listener. But please subscribe, and we'll get you. And our FLSA class next week. If you're interested in the FLSA, you have overtime issues, or not even overtime, right? Because we've got volunteer departments that their concern isn't overtime. Their concern is whether or not the person that's providing the service has actually become an employee. They're not a volunteer. Have they become an employee? So we cover all of that. So
absolutely.
All right, Bill. Well, thank you. Thank you again, and thanks folks for listening.